Okay, so this will be jury charge at 180
Okay.
for the record. Ladies and gentlemen of the jury, it becomes my duty as judge to instruct you concerning the law applicable to this case, and it is your duty as jurors to follow the law as I shall state it to you. The function of the jury is to try the issues of fact that are presented by the allegations in the indictment filed in this court and the defendant's plea of not guilty. This duty you should perform uninfluenced by pity for a defendant or by passion or prejudice against him. You must not suffer yourselves to be biased against a defendant because of the fact that he has been arrested for this offense, or because an indictment has been filed against him, or because he has been brought before the court to stand trial. None of these facts is evidence of his guilt, and you are not permitted to infer or to speculate from any or all of them that he is more likely to be guilty than innocent. Gentlemen, you are to be governed solely by the evidence introduced in this trial and the law as stated to you by me. The law forbids you to be governed by mere sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feeling. Both the state and the defendant have a right to demand, and they do demand and expect, that you will conscientiously and dispassionately consider and weigh the evidence and apply the law of the case, and that you will reach a just verdict regardless of what the consequences of such verdict may be. That verdict must express the individual opinion of each juror. Gentlemen, you are the exclusive judges of the facts and of the effect and value of the evidence, but you must determine the facts from the evidence produced here in court. If any evidence was admitted and afterwards was ordered by me to be stricken out, you must disregard entirely the matter thus stricken, and if any counsel intimated by any of his questions that certain hinted facts were or were not true, you must disregard any such intimation and must not draw any inference from it. As to any statement made by counsel in your presence concerning the facts in the case, you must not regard such a statement as evidence, provided, however, that if counsel for both parties have stipulated to any fact, you are to regard that fact as being conclusively proved. And if in the trial either party has admitted a fact to be true, such admission may be considered by you as evidence in the case. The state and the defendant are both entitled to the individual opinion of each juror. It is the duty of each of you, after considering all the evidence in this case, to determine, if possible, the question of the guilt or innocence of the defendant. When you have reached a conclusion in that respect, you should not change it merely because one or more or all of your fellow jurors may have come to a different conclusion, or merely to bring about a unanimous verdict. However, each juror should freely and fairly discuss with his fellow jurors the evidence and the deductions to be drawn therefrom. If after doing so, any juror should be satisfied that a conclusion first reached by him was wrong, he unhesitatingly should abandon that original opinion and render his verdict according to his final decision. The attitude and conduct of jurors at the outset of their deliberations are a matter of considerable importance. It is rarely productive of good for a juror upon entering the jury room to make an emphatic expression of his opinion on the case, or to announce a determination to stand for a certain verdict. When one does that at the outset, his sense of pride may be aroused, and he may hesitate to recede from an announced position if it is shown that it is fallacious. You must remember that you are not partisans or advocates, but rather judges. The final test of the quality of your service will lie in the verdict which you return to this court, not in the opinions any of you may hold as you retire. Have in mind that you will make a definite contribution to the efficient judicial administration if you arrive at a just and proper verdict in this case. To that end, the court reminds you that in your deliberations in the jury room, there can be no triumph except the ascertainment and declaration of truth. In this If in these instructions any rule, direction, or idea be stated in varying ways, no emphasis thereon is intended by me, and none must be inferred by you. For that reason, you are not to single out any certain sentence or any individual point or instruction and ignore the others, but you are to consider all the instructions as a whole, and are to regard each in the light of all the others. The order in which the instructions are given to you has no significance as to their relative importance. At times throughout the trial, the court has been called upon to pass on the question whether or not certain offered evidence might properly be admitted. You are not to be concerned with the reasons for such rulings, and are not to draw any inferences from them. Whether offered evidence is admissible is purely a question of law. In admitting evidence to which an objection is made, the court does not determine what weight should be given such evidence, nor does it pass upon the credibility of the witnesses.
Wow.
Okay, wow.
Yeah, it's because sometimes it cuts. I have a really slow internet, so it cuts out.
Oh, no.
Yeah.
Well, that's too bad.
Yeah.
We are recording these and uploading them, the practice material, all to the media website, which I believe you can access.
I think I tried it and I couldn't figure it out.
Oh, no, really? Because
Yeah.
I don't know if it would go any better doing it that way, because that would be, I don't know, it might be different.
Yeah, I'm gonna have to try that tonight.
So yeah, see if that works out any better.
Yeah.
Okay, well, and I apologize for my mistakes as I was reading.
That's okay.
There were a couple things that were kind of funky in the material, and so I thought that it wasn't making sense to me. And so that was part of the problem. Okay. Let's see. I have two other pieces of congressional material, which is everyone's favorite. Yeah. And so do you have an opinion whether you would like to hear about refunding the National Institutes of Health, or something about global warming? This other one seems to be about.
Global warming is fine, whichever.
Okay, well, let's look at that one and see how that goes. So speed-wise, do you think that reading at 180 is probably best for you now?
Yes.
Okay.
You can speed it up.
Okay, well, we may do that too, so.
Yeah, I can't read back though.
At that speed, you mean? I mean, I could slow it down for some readback.
Okay.
But let's see how this goes. Maybe we'll do a little and then we'll slow some down for some readback.
Okay.
All right, so this is congressional material, and I'll begin at 180 for the record. I want to give my personal congratulations to Congresswoman Tauscher, and I just look for great things out of you. Congratulations. I rise to speak against this rule. This rule is blatantly unfair to the American people. It is quashed. It is. It has prevented good amendments to be introduced on this floor and to have the proper debate that we should have over something that is extremely important, as this bill is. We have just gotten this, but let me tell you what this bill is, America, Madam Speaker. This bill is going to kill millions of jobs in America. People are going to be put out of work because of this bill. Now, we hear all the time about global warming. Actually, we have had flatline temperatures globally for the last 8 years. Scientists all over this world would say that the idea of human-induced global climate change is one of the greatest hoaxes perpetrated throughout the scientific community. It is a hoax. There is no scientific consensus. But this is going to kill jobs. It's going to raise the cost of food. It's going to raise the cost of medicines. It's going to raise the cost of electricity and gasoline. Every good and service in the country is going to go up, and who is going to be hurt the most? The poor, the people on limited incomes, the retirees, the elderly, the people who can least afford to have their energy taxes raised by, MIT says, over $3,100 per family. This rule must be defeated. This bill must be defeated. We need to be good stewards of our environment, but this is not it. It's a hoax. I encourage people to vote against the rule and the bill. Madam Speaker, I yield 3 minutes to the gentlewoman from Texas, Ms. Jackson Lee. I would like to thank the gentlelady from California, and I would like to express my recognition that this is heavy lifting. This is for the courageous and the willing who want to see a new vision. I am well aware of the hard task that our friends on the Rules Committee had. So I am voting for this rule, and I come from the energy capital of the world. We are proud to say that. We have obviously lived in the clothing of the energy of this past century and what continues in the century to come. But I realize that it should be a seamless energy policy. I represent the city of Houston, hard-working Americans, and so it's important as we listen to our friends on the other side of the aisle. This is a challenging time. It is a time for heavy lifting, to be able to look at what happened in the past. We realize that under the Bush administration, the increase in what we pay for gasoline went from $2,000 plus to $4,000 plus. We also realize that in this legislation, there is a great effort to ensure that the American people are addressed fairly. So 40% of American households will face almost no cost as a result of this bill. Let's get the facts. We know that the CBO score of the bill that has been utilized by our friends on the other side of the aisle is incorrect, because the increase on building our energy resources will wind up being $770 per family. But there are issues that we should continue to be focused on, and therefore we should look to ensure that no American who may be displaced for any reason, new technology is not in essence overlooked. There are millions of dollars for green energy job training in this bill. I am looking to offer amendments that focus on making sure that any dip in job positions will be monitored by the Labor Department, and in fact, that resources be available for all Americans. But what we are trying to do here is to build a new culture and work with what we have, to build the seamless resources that we have across the country and guide the carbons out of the air and make our quality of life better, and at the same time give us a new vision for how we handle the energy needs of our nation. And so it is important that we recognize that there is a structure to capture that carbon. There is a response to those who are in essence impacted. There are credits that are going to be given. At the same time, I was concerned about the labeling of different buildings, and we are working on language that would ensure that older buildings won't have to participate in the assessment of whether your building is energy efficient. It will be for new construction. So we are making our way, because in fact this is a beginning. We will be working with the Senate. We will be working with the President. We will be working on behalf of the American people. We have to get started. We have to be innovative. We have to claim the 1.7 million jobs that this bill will create. I think America wants us to do that. Okay, so that was 180 as well. So why don't we slow some down? And this is a different speaker again. It's kind of going back and forth. So we'll slow this down to more like 160.
Okay.
And have some read back.
Okay.
All right. For the record. Madam Speaker, I rise in opposition to this rule and to the underlying legislation. I am just not sure to which I am more opposed. Americans are watching as from Iran to North Korea, the forces of darkness are attempting to silence the voices of democracy and freedom. The irony is, on this day, the democratic process and our nation's economic freedom are under threat, not by some rogue state, but in this very chamber in which we stand. Good people may disagree on the impact of the merits of this bill, but no one can disagree with the fact that the Speaker and our Rules Committee have silenced the opposition of 224 amendments. Madam Speaker, one, and I repeat, one amendment was actually made in order. Madam Speaker, I offered an amendment, which was of course not made in order, that would have allowed a state to opt out of this legislation. How can we not give them the ability to say that their citizens and their businesses simply cannot afford this Pelosi global warming tax? For some of them, this bill will be an economic death sentence. And yet, Madam Speaker, this House will not have a chance to vote on this amendment or anything of the other 222. They were banned from being debated and voted upon in this, the People's House. I call upon every member of the House, oppose and defeat this rule, not just for the sake of the democratic process, but for the sake of our nation's economy.
Okay. Should I start from the beginning?
Yes, hold on just one second. I'm going to pause. We're going to repeat the portion for it that I did for readback, and so we will do it now at 180.
Okay.
Okay, for the record. Madam Speaker, I rise in opposition to this rule and to the underlying legislation. I am just not sure to which I am more opposed. Americans are watching as from Iran to North Korea, the forces of darkness are attempting to silence the voices of democracy and freedom. The irony is, on this day, the democratic process and our nation's economic freedom are under threat, not by some rogue state, but in this very chamber in which we stand. Good people may disagree on the impact of the merits of this bill, but no one can disagree with the fact that the Speaker and our Rules Committee have silenced the opposition of 224 amendments. Madam Speaker, one, and I repeat, one amendment was actually made in order. Madam Speaker, I offered an amendment, which was of course not made in order, that would have allowed a state to opt out of this legislation. How can we not give them the ability to say that their citizens and their businesses simply cannot afford this Pelosi global warming tax? For some of them, this bill will be an economic death sentence. And yet, Madam Speaker, this House will not have a chance to vote on this amendment or any of the other 222. They were banned from being debated and voted upon in this, the People's House. I call upon every member of this House to oppose and defeat this rule, not just for the sake of the democratic process, but for the sake of our nation's economy.
I don't think I can read that back. I can try, but it was terrible.
That's okay. Let's, and I'm having trouble with the lights here.
That's fine.
My little light is not really giving enough by itself. Okay, so let's repeat it one more time. And I'm going to go a little faster, and then we'll do it again at 180 and see if you
feel comfortable.
Get it a little more, because repetition sometimes is helpful.
Yes.
Okay. All right. So here it is at 190. Madam Speaker, I rise in opposition to this rule and to the underlying legislation. I am just not sure to which I am more opposed. Americans are watching as from Iran to North Korea, the forces of darkness are attempting to silence the voices of democracy and freedom. The irony is, on this day, the democratic process and our nation's economic freedom are under threat, not by some rogue state, but in this very chamber in which we stand. Good people may disagree on the impact of the merits of this bill, but no one can disagree with the fact that the Speaker and our Rules Committee have silenced the opposition of 224 amendments. Madam Speaker, one, and I repeat, one amendment was actually made in order. Madam Speaker, I offered an amendment which was, of course, not made in order that would have allowed a state to opt out of this legislation. How can we not give them the ability to say that their citizens and their businesses simply cannot afford this Pelosi global warming tax? For some of them, this bill will be an economic death sentence. And yet, Madam Speaker, this House will not have a chance to vote on this amendment or any of the other 224. They were banned from being debated and voted upon in this, the People's House. I call upon every member of this House, oppose and defeat this rule, not just for the sake of the democratic process, but for the sake of our nation's economy. Okay. All right, so now let's do it again, back at 180. Okay. Let's see how it feels for the record. Madam Speaker, I rise in opposition to this rule and to the underlying legislation. I am just not sure to which I am more opposed. Americans are watching as from Iran to North Korea, the forces of darkness are attempting to silence the voices of democracy and freedom. The irony is, on this day, the democratic process and our nation's economic freedom are under threat, not by some rogue state, but in this very chamber in which we stand. Good people may disagree on the impact of the merits of this bill, but no one can disagree with the fact that the Speaker and our Rules Committee have silenced the opposition of 224 amendments. Madam Speaker, one, and I repeat, one amendment was actually made in order. Madam Speaker, I offered an amendment which was, of course, not made in order that would have allowed a state to opt out of this legislation. How can we not give them the ability to say that their citizens and their businesses simply cannot afford this Pelosi global warming tax? For some of them, this bill will be an economic death sentence. And yet, Madam Speaker, this House will not have a chance to vote on this amendment or any of the other 222. They were banned from being debated and voted upon in this, the People's House. I call upon every member of this House, oppose and defeat this rule, not just for the sake of the democratic process, but for the sake of our nation's economy.
Okay, I can try. I did a lot better than the first one.
Oh, okay. Okay, switching material now, we have something from the guide for counsel in cases to be argued before the Supreme Court. And we are at number 2, time. Your argument time is normally limited to 30 minutes. You need not use all your time. Counsel for the respondent in Whitfield versus United States, 543 U.S. 209, 2005, argued for only 10 of the allotted 30 minutes. Counsel for the respondent in Burgess versus United States, 553 U.S. 2008, argued for only 7 of the allotted 30 minutes. Both respondents prevailed in unanimous decisions of the court. Unless you make other arrangements with the marshal, the white light on the lectern will be activated when 5 minutes of your allotted time remains. The red light will be activated when your time has expired. Upon request, prior to argument, the marshal will flash the white light at a time requested by counsel. When the marshal activates the white light, you should be prepared to stop your argument in 5 minutes. When the red light comes on, terminate your argument immediately and sit down. If you are answering a question from a justice, you may continue your answer and respond to any additional questions from that justice or any other justice. In this situation, you need not worry that the red light is on. Do not, however, continue your argument after the red light comes on. In a divided argument, it is effective for counsel to inform the court of their argument plan. For example, petitioner's counsel might say, I will cover the Fourth Amendment aspects of this case, and counsel for the amicus will argue the Fifth Amendment issues. Regardless of how many attorneys argue in a case, only one is permitted to present rebuttal argument. If 2 counsel argue for the petitioner, the one who argued first should be the one to present rebuttal. A petitioner's counsel who wants to reserve time for rebuttal should, about 5 minutes before the allotted time is to expire, white light, say, if there are no further questions, I would like to reserve the remainder of my time for rebuttal. Petitioner's counsel then sits down and the Chief Justice calls on the respondent's counsel for argument. Respondent's counsel proceeds to the lectern, waits for the acknowledgement by the Chief Justice, and then opens with, Mr. Chief Justice, and may it please the court. When respondent's counsel is finished and gathered all items from the lectern, petitioner's counsel should return to the lectern and wait for acknowledgement by the Chief Justice, at which time he will say, e.g., you have 5 minutes remaining. You may begin your rebuttal at this time without having to repeat, Mr. Chief Justice, and may it please the court. Promptly and quietly vacate the front argument table after the Chief Justice announces that the case is submitted. Counsel at the backup tables should move to the front tables for the next case. You may move to the backup table if you wish to listen to the next argument. 3. Protocol. The Supreme Court is not a jury. A trial lawyer tries to persuade a jury with facts and emotion. At this court, counsel should try to persuade the court by arguing points of law. Your argument should focus only on the question or questions presented in the petition that was granted. Do not deviate from it. Ordinarily, the justices will know whether you are making your first argument before the court. Be assured that some first-time arguments have been far superior to presentations from counsel who have argued several times. As noted, if your argument focuses on a statute, regulation, or ordinance, be sure that the law is printed in full in one of your pleadings so that you can refer the justices to it and they can be looking at it during your argument. Counsel for the petitioner need not recite the facts of the case before beginning argument. The facts are set out in the briefs which have been read by the justices. You should speak in a clear, distinct manner and try to avoid a monotone delivery. Speak into the microphone so that your voice will be audible to the justices and to ensure a clear recording. Avoid having notes or books touch the microphones since this interferes with the recording process. Under no circumstances should you read your argument from a prepared script. You should not attempt to enhance your argument time by a rapid-fire staccato delivery. Exhibits can be useful in appropriate cases, but be very careful to ensure that any exhibit you use is appealing, accurate, and capable of being read from a distance of about 25 feet. Be sure to explain to the court precisely what the exhibit is. Your counsel must advise the clerk of the intent to use an exhibit as soon as possible. For a good example of an exhibit used at oral argument in this court, see Shaw versus Reno, 509 U.S. 630, 658, 1993. You should be knowledgeable about what is and is not in the record in your case. Justices frequently ask counsel if particular matters are in the record. If you are asked a question that will require you to refer to matters not in the record, your answers should so state. Then proceed to respond to the question unless advised otherwise by the justice. Never interrupt a justice who is addressing you. Give your full time and attention to that justice. Do not look down at your notes and do not look at your watch or at the clock located high on the wall behind the justices. If you are speaking and a justice interrupts you, cease talking immediately and listen. When a justice makes a point that is adverse to you, do not stonewall. Either concede the point as appropriate or explain why the point is not dispositive of your case and proceed with your argument. Do not correct a justice unless the matter is essential. In one case, a justice asked a question and mentioned waiver. Counsel responded by stating that a forfeiture rather than a waiver was involved. The distinction was irrelevant, but the comment generated more questions and wasted valuable time. Be careful to use precise language. In one case, counsel stated the supremacy clause does not apply in this case. A justice responded, the supremacy clause applies in every case. Perhaps counsel meant that the statute in question does not conflict with the supremacy clause. Be careful not to use lingo of a business or activity. The court may not be familiar with such terms, even if widely understood within that business or activity. For example, you should not say double link connector or Section 2B claims unless you have explained what those terms mean. Similarly, do not use the familiar name of your client during argument. For instance, say Mr. Clark denied the request rather than Buddy denied the request. Do not refer to an opinion of the court by saying, in Justice Ginsburg's opinion. You should say, in the court's opinion, written by Justice Ginsburg. If you quote a document verbatim, e.g. a statute or ordinance, tell the court where to find the document, e.g. page 4, appendix B to the petition. Attempts at humor usually fall flat. The same is true of attempts at familiarity. For example, do not say something like, this is similar to a case argued when I clerked here. Do not denigrate opposing counsel. It is far more appropriate and effective to be courteous to your opponent. Avoid emotional oration and loud, impassioned pleas. A well-reasoned and logical presentation without resort to histrionics is easier for listeners to comprehend. Do not argue facts. Argue to the question or questions of law presented in the petition for a writ of certiorari that was granted. Counsel for respondents are often effective when they preface their arguments by answering questions that petitioner's counsel could not answer or answered incorrectly or ineffectively. This can often get you off to a positive start. If your opponent is persuasive on a certain theme during argument, especially one that was not anticipated, you should address that issue at the outset of argument or rebuttal argument rather than adhere to a previously planned presentation. You take a great risk if you ignore a persuasive point made by your opponent. Rebuttal can be very effective, but you can be even more effective if you thoughtfully waive it when your opponent has not been impressive. If you have any rebuttal, make it and stop. There is no requirement that you use all your allotted time.
Okay. Well, thank you so much. And so I can find these recordings on the same website, right?
Yes.
Okay.
You can. All right. Well, have a good weekend.
You too.